Sewer and trash, just the sewer and trash.
But sir, you said 53. I think you erred when you said that was an operation of law. Well, listen, you can't have an operation of law when you've got facts in dispute. There are major facts in dispute.
And what are they?
Where did he get authority, legal authority, to determine that Title 53 applied to me? What facts did he have that Title 53 applied to me?
Sir, it may not apply to you, but applies to the property itself.
Well, sir, he needs to have ownership or interest or taxable interest in the property for it to apply. He just can't go run around.
You're not pursuing any liability against you.
Oh, no, yes, you are, sir. Listen, and I got case law here says to the opposite, okay? Yes, you are. Basically, that's a violation of my property rights, okay? First of all, Title 53, the way the Municipal Claimant Tax Lien Act, the way it's set up, there's no appeal process involved with Title 53. And I actually read Pennsylvania case law on that. So, and it states that it does affect the property owner's rights in the property. So Mr. Today has no ownership interest or taxable interest, and neither does the Beverly Park have any ownership interest or taxable interest in the property. You got to have ownership interest or taxable interest in the property to bring an in rem action. You can't sue my property. The law doesn't work like that. And if this is the road we're going to go down to, that's no problem. Because I'm going to deal with Mr. Today in federal district court. He's going to take him for a ride he's not going to believe by the time I'm done with him. Because he has no authority to determine what statutes apply to me and that he could apply them to me. This is a violation of due process that violates Article 1, Section 1, Section 1, where I have a right to acquire, possess, and protect property. It violates Section 11, which is due process, and it violates my right to trial by jury. There's never been a jury trial here. There's never been any kind of court proceeding here. This is all done by the stroke of a pen of an attorney. An attorney's writings are not facts. Now, this stuff works. Listen, I'm not saying that the Municipal Claimant Tax Lien Act are illegal. They're illegal if they're applied in the wrong way. And that's what he's doing. He's trying to apply an act that's written for commercial legal entities upon private property. And he can't do it. He can't bring an in rem action. He's doing this in rem action because he can't bring a standard cause of action against me. This is a simulation of legal process. These are color of law actions. There is no way this guy could take property, and that's what he's doing. This is theft under 3921B. It's theft of immovable property in Pennsylvania. He's exercising rights and property that neither he nor his client have. That's flat out theft. He should be arrested right now. And if he thinks this is a game and he wants to laugh about it, I want to see how he answers that pleading in federal district court, because he can't take Title 53 and apply it to me. What authority does he have to do that? Can he cite an authority?
Mr. Julia, let's have Mr. Today, on behalf of the borough, respond. And then I'm going to ask you to speak to the last outstanding issue, which is the motion for summary judgment for a moment. Okay. And then I'm going to ask you, sir, to finish up and provide you with any additional testimony on any subject whatsoever pertaining to the matter before me today.
I have just one question, Mr. the defendant.
Sure.
Do you believe that this property is subject to real estate tax here in Pennsylvania?
Sir, no, it doesn't fall under real estate tax. If you read Title 72, Title 53, Title 61, the Tax Reform Act of 1971, and the Local Tax Enabling Act, you would know that this is not taxable real estate.
Okay.
This particular project on Main Street is not taxable real estate?
No, it doesn't fall under Title 72.
Subject to borough real estate taxes or county real estate taxes?
Well, that's their claim. That's his claim. Now, he's saying that's my burden of proof. No, he's the one that has the burden of proof. First, he's got to prove the statute applies to me. What he's doing is he's jumping in the Municipal Claimant Tax Lien Act, which puts the burden of proof on whoever they file it against. So, given this standard, as long as he files a municipal claim, somehow burden shifts to me. No. He's first got to prove that Title 53 applies to me and that the Municipal Claim Tax Lien Act applies to me.
I'd just like to reassert the fact that, again, he's never opened up an estate. He's never filed a petition to intervene.
Mr. Day, may I ask you a question?
He's probably practicing law without a license here in Pennsylvania.
Oh, objection! Objection!
He has not filed an affidavit of defense, correct?
No, he does not.
Okay. Nor have I heard any testimony on his part confirming anything defective about the municipal claim, correct?
That's correct, Your Honor.
Okay. Do you have any obligation here today to provide you with any testimony other than the information I've already received as well?
Your Honor, I believe that this was on the motion, so I don't think that, I think the legal arguments speak for themselves.
Your motion to strike.
Yes, his motion to strike and my response.
Right. And then of course, the motion for summary judgment, that's pertaining to a different caption.
That's correct.
The Johnson Avenue property, 62985, 2021.
That's correct.
Okay, now the fact that I have already previously signed order on August 30th, 2022, dismissing the motion to strike.
That's correct.
I would think this motion for summary judgment is now moot.
No. Objection.
Am I correct or not correct?
I believe it is moot for a whole different reason, Your Honor.
What does that mean?
We had filed the writ of sarfaccius on the defendant at that August 30th hearing date. He then has the opportunity to file. The correct
Objection.
process is to file an affidavit of defense to challenge the
Objection.
facts or the claim. In this case, he's filed a motion for summary judgment. Now, as I've indicated, this is a strict statutory proceeding.
Objection.
In the Municipal Claims and Tax Liens Act. There is no provision under that act for the filing.
We're not under that act.
For summary judgment. So that's why we believe that his motion for summary judgment is inappropriate.
Again, sir, the claim, where did he get the authority to move under the claim? He don't have anything.
Okay, Mr. Becker, would you like to finish up with
Sure.
any testimony, any evidence, or any argument?
Mr. Dozier, the pleadings of an attorney are not facts. He don't even have a written statement from anyone from the borough stating that they authorized and directed him to file this. Because if he does, I will go after them also. He's got no one stepping up from the borough that's going to
Has
do.
verifications been provided to the court?
What's that?
Verifications been provided to the court?
On our,
Is anyone here to verify I owe money?
on the documents that we filed, yes.
Sir, I have record requests where Mr. Tutak over there stated, he's the borough manager,
Right, you know him?
I've had dealings with him, where he's been asked who directed and authorized Robert P. Today to file the municipal claims. He said he has no records or information in his possession of that. So that defies logic and is incredulous to think that the borough doesn't have records of who directed and authorized Robert P. Today to file municipal claims. They were asked what evidence they have, or what records or information they have that Title 53 applies to my property. Mr. Tutak, under penalty of perjury, stated he has no records in the borough's possession that Title 53 applies to my property. When asked what debt is owed to the borough of me, either from me or my property, Mr. Tutak again stated, and it's in the records, under penalty of perjury, they have no records or information of a debt owed to the borough. So then we turn around, completely opposite of what Mr. Diday's doing. Mr. Diday has moved this case by himself. Mr. Diday has a contract with the borough, and you'll talk about practicing law without a license. He's over there managing property without any ownership. He's got no ownership interest or rights in property, and he's filing liens against property that he don't own and that his client don't own. If he don't think that's a serious thing, that's a serious matter, we're going to have an interesting time coming up in the next few months. Me and Mr. Diday are going to get to know each other very well. There is no way that an attorney can determine on his own that Title 53 applies, and that then allows him to move into the Municipal Claim and Tax Lien Act and to file security instruments against property that he don't own. Is the borough claiming they have ownership interest or taxable interest in his property? Do they have any evidence that they have taxable interest in his property? Can we get an answer?
Well, actually, they do have ordinances and resolutions which assess real estate taxes against the property.
Objection. Ordinances and resolutions are bylaws. They are not laws of the state of Pennsylvania. Wait, sir, the Borough Ridley Park Council can't make laws. Only the Pennsylvania Assembly can make laws. So ordinances and resolutions are not laws. So the next question would be, what facts does he have that the ordinance and resolutions apply to me? Does he have any facts?
With regards to both matters in front of me, I'm going to require the parties, I'm going to invite the parties, I'm not going to require them, I'm going to invite them, that would We've been doing the